Veterans Air, the Veterans Hour, your source for news, talk, and uncensored commentary here on the Lone Star Community Radio Station. I'm Douglas B. I'm your host, and you can listen to us live the first Tuesday of every month on VeteransAir.us or here on Conroe's very own FM 106.1 and 104.5. As always, before we get started, do a little housekeeping. You can contact Veterans Air through the website at www.VeteransAir.us. Leave us a message. Better yet, text us in the studio on our Google phone, which I currently have turned off, but I really honestly do have it. Before we get started today into the show, I'm sad to report that Dangerous Dan, the Muffin Man, is no longer part of this show. He got a little too mouthy, and I had to backslap him. No, seriously. He's left, and this is what he says, and I quote, "I finally escaped Douglas Lair, and I'm free to wander around Oklahoma, Missouri, and Kansas City." I'm sure that Dan will miss Texas, and of course, Veterans Air, loyal listeners, but I understand he's got to go where the work goes. Dan, I know you're listening today, because you said that you'd be listening every time I'm on the air. So welcome, Dan. I miss you. We're here with the lawyer ladies from the Legal Connection, and they want to know, where are their muffins? Just because you're gone does not mean that your responsibilities have stopped. Hey, listen, I wanted to give a shout out before I forget to next door to Carly's Main Street Mercantile. Carly, if you're listening, hi. If you guys have not checked out the new store next to the radio station, drop into Carly's, tell her that Veterans Air said for you to come by, pick up something ice cold and something sweet to drink. We have some birthday wishes that I have to get out to today before we get started. This month, we have a bunch of birthdays. A big happy birthday to Brother Johnny, Lucas, RC, Master Chief Pete, Ralph, and our favorite veteran liaison, Ashley. And of course, let's not forget Keith over at the post office. Happy birthday to y'all. So, today, as promised, for the past couple of months, we've actually got it together. The lawyer ladies from the Legal Connection, Tony and Cheryl, and you can catch their show right before this show and every Tuesday at noon on the Lone Star Community Radio. Tony and Cheryl, they're going to help us today as we talk about wills and probate. Yes, that nasty thing. We're going to have to find out what it is that surviving spouses need to know and what us as veterans need to do for those that love us, that we're leaving stuff to. And I got to tell you, for me, this reaches home because I've had to do this twice already. Once for my adopted grandfather and once for my stepfather. Both are veterans, both have passed. And I want to let you know, if you're listening to me, you need to be prepared. Go back to the old Boy Scout adage, always be prepared.
Yes.
Tony, Cheryl, welcome to the show. I'm glad we finally got together. Thank you for being here. Why don't you guys introduce yourselves? Tell us a little about you.
Okay, I'm Tony Collins, and I've been an attorney for about 20 years now, and pretty much do every type of law imaginable. And you had over in Montgomery County and all the surrounding counties, and in Texas and federal bankruptcy, the whole bit. But you had asked us to be on your show, and I've been trying to get on your show for some time because
I know, it's all my fault.
I am very interested. I have questions for you, you being a veteran and knowing about having gun issues and probably knowing a lot more. So we really need to have you on our show to talk about those issues so that we can have your experience to for our listeners to kind of hang on to and learn from.
I am a staunch Second Amendment supporter, and if there's gun owners out there, if you're not doing it right, shame on you. If you're a veteran and you're not doing it right, swing on by the studio so I can backslap you.
And I'm Cheryl Ellsworth Jahani. I practice here in Texas, primarily Montgomery and Harris County, but I'm all over the place. And just like Tony, I practice all kinds of law. I was talking to an attorney the other day in Austin who said he had an open law policy, that he took any case that opened the door. That's what he said. So,
Man, that's pretty bad.
I know. But that's what I do.
Are you guys in the same law firm?
No, we're just friends.
No, you know how we
but
met?
we do tell people when we go to hearings together and stuff that we're partners.
Yeah. We met oddly because her, unfortunately, talking about estates, wills, and probates today,
Right.
our next door neighbor passed away very young, unexpectedly. So you should be prepared.
He was 52, maybe.
Yeah, and it kind of brings home that you don't know when your last day is going to be, and we were stunned because he was, he had a family, he had kids, he was our neighbor. I mean, I just seen him.
So
and then-
Tony's next door neighbor was my son-in-law's father. And so I was facilitating an estate sale, and Tony walked next door to go
Yeah, I
see
had
what's
my little
going on
golf
over
cart.
there.
I was like, because we love going to auctions and stuff, and I drove over there, and she was just sitting there, and she asked me something, and it occurred to me that I'd had some experience with what you were asking me about, where I could help her. Not trying to, I had too much work now, and just like this guy about the open door policy, I would never do that. I've got the shut the door policy.
Right,
I am
she
so
does.
busy. I'm giving stuff away right and left because I do good, I win, but I do good and win because I make sure that I'm prepared. I read everything. I keep up with I make sure I know everything before I go in. I may not be the best, I don't look like Racehorse Haynes walking into a court, but I think like in all
disagree
things
with
in
that.
life.
You're pretty and attractive,
Aw.
and people, you get respect when you walk into court. That's not true.
It's scary, but I tell you what, I will win generally, and I won't go to court unless I believe that I've got the facts to win because I am prepared. And I always, and I'm not going to go off a tangent, but I always pray about it because whatever God's will is the way it's going to be. It may not be that I'm supposed to win that day, but generally I do.
Well, but Tony, you already are on a tangent because how we met was, which is what we were originally talking about. No, you walked in the garage and you looked at me and you pointed to the garage door leading to the house, and I said, "Yeah, there's more stuff inside." And she walked by, and I thought, "Wow, she was so pretty." And then we go back in. I went back in for some reason, and she was asking me about a printer. And then that's how we found out we'd both gone to law school. We went to the same law school, and we just became friends.
After that, we just
Thank God for that.
Yeah.
Well, let me ask you this question. Since you don't both work for the same law firms, you're doing your own things. How can my listeners get hold of you if they need something? If they need a lawyer?
Well, I will let Cheryl is always our, call girl that sells, gives a deal.
Damn!
Tony, that is not true. Send us your questions at questions@legalconnectionshow.com. I don't know, Dick. They can message us live on Facebook, but then after we're off of Facebook, can't they also send us messages to our Facebook thing? Yes.
Well, it's pretty easy name. We got the legalconnectionshow.com, and it's TLC, and we
I'm
register.
providing the information on the Facebook Live for Veterans Air right now.
Oh, okay,
Okay.
great.
People can find
And then
it.
we
And
also
then-
I gotta
Thank
do
you.
something nice for you someday. Not soon, but someday.
Thank you.
And then we
for
also
doing
have a
that.
Google phone. It's 281-579-5862.
So you caught us off guard. We were going to give your listeners everything they need to know about how to handle the, if their spouse dies and they're a veteran. We were like ready to go. We were going to be like
And then Tony's
Non-people.
Tony's email is also iceattorney@aol.com, and I am christinejahani@gmail.com.
Outstanding. So you heard it here first, and our wonderful engineer Dick is putting it on the feeds now. So you'll be able to call them and hire them should you need them. And as I said before, if you do not have a will, shame on you. And Tony is biting at the bit here. So we're going to jump right into it. I polled the listeners out there, and I have the top 3 questions that came back from this for wills. And the overall number 1 question I got was, what is the definition of a legal will in Texas?
And I'm going to let Cheryl take that because although I could talk forever, I always talk forever, and I feel terrible.
It's only an hour show.
I know.
This can't be forever. Okay, to be valid, a will must be in writing, signed by you or another person at your direction and in your presence. In Texas, we have, the conscious presence test.
Right.
I mean, the person who's drafted the will. Okay, well, let me back up just a little bit because a will is an instrument or a document that says where you want your stuff to go after you die. That's what it is.
All it is you're giving your desire. You're documenting your desires of how you want your property to be disposed of after your death. That's all a will is.
Or
It can be
distributed. Sometimes we use these words disposed of that.
Yeah.
The listeners may not understand it.
not thrown out. That's
Where
right,
we want it to
distributed.
go.
But I will go here, and I to kind of offset a little bit something you said just a little bit earlier. I don't believe it needs to be a formality, and I've always been on the mind that people, even as an attorney, that people don't need a will, because if you're not here, why do you care? Just let them go crazy and kill each other over your stuff after you're gone, and just see what happens.
You say that, but I have to let
She
you know.
doesn't
I have to
mean
let you know that those people that you hold dear to you become totally different people
I know.
after you've passed.
I know.
You look at them and you go, "What? Are you serious? Calm yourself. It's only stuff."
And I think their relationship
Wasn't even your stuff.
That's right. It wasn't even your stuff.
If you're dying, I think your relationship with them is different than their relationship with each other, you know, and they start relating to each other based out of the relationship they have with each other. They'd never do that in
If
front
it's
of
a
you.
parent,
if
though,
you're the mom,
There's
or
a
grandma.
lot of stuff going on. Were you the favorite son? Were you were favored? You got that already while they were alive. You know, it's almost biblical, like the son that goes away and gets all his stuff, like while Dad's still alive, and then Dad welcomes him back after he squandered, and the son that stayed is. And
Mad.
the prodigal son, that he's very upset because I was here, I took care of the farm, I've done all this stuff, and now you're welcoming him back with open arms like he never
And had a
And
party
that
for
goes
him.
on all the time.
But having defined a will, so you write out where you want your stuff to go and who gets it. But a will has to be valid. So in order to be valid in Texas, it must be in writing, signed by you or another person at your direction and in your presence, and attested in your presence by at least 2 credible witnesses over the age of 14.
I don't think it has to be in writing anymore. I think it can be oral. It's hard to prove.
Well, no, there are oral wills, but no, it's got to be in writing. There's a holographic will. Now, that's the one that you handwrite yourself.
That's my favorite will. I will say that right now. If you want to have a real short will, let's say that you are in a car accident and you're dying right there and you don't have a will and you've got a pen and a paper handy, it doesn't even have to say will on it. You can literally, in your handwriting, say everything I own goes to you, or goes to Cheryl, or goes to producer Deck, and then sign their name. And that is a will, because it shows everything I own goes to you. Maybe you want to put upon your death, but it's obvious that your intent is to distribute your property upon your death in accordance with your wishes. And that's it doesn't even have to say the word will or have a date on it, as long as it's all in handwriting.
I want my girlfriend Becky to get everything I own. There was a case in Colorado.
I would probably put in their will on the top just to make sure, because
Right.
you have to show that that's the...
Doesn't even have to be dated, but I would date it.
Yeah, but let's say that something's happening, or let's say at the last minute someone died, and you realize the person that shot you's left, and they were the one that was going to get everything. Of course, in Texas, if you're the person that kills them, you're not going to be able to get that. There's a law that says that the murderer can't benefit by your demise. But anyway, that all being said, if you decided at the last minute in your dying moment that you want it to go to somebody else, then you can literally create a new will that will replace all other wills at that moment if you do it in handwriting and you sign it. And it doesn't take much to make it right. So I love holographic wills for that reason.
So my adopted Texas grandmother, Miss Honey, when she passed, didn't have a will that we knew of. But going through her paperwork, we found a will on a legal pad in her handwriting.
Okay.
Hey, she had a will.
And there wasn't any changes to what the family expected. But this will doesn't need to be drawn up by her lawyer.
She wrote it in her own handwriting?
She wrote it in her own
Did
handwriting.
she sign it?
She signed it.
No.
Holographic will.
That's
That is
called
a valid
holographic.
will.
That's what Tony was just talking about.
A valid
valid.
handwritten will.
It doesn't need to be, notarized by the notary
No.
public or anything like that.
No, isn't that
literally-
crazy? But a will, to be valid, when it's in writing and drawn up by an attorney, it does need to be attested
if
by
it's
2
not
witnesses.
in that person's fully in their handwriting, there's some question about its authenticity, which is why it has to be, there has to be like the will dance. And if it's not self-authenticating, then the 2 witnesses that sign in the presence have to be there to prove it up when you actually probate it. So it's a lot more complex, and that's why it's helpful. You can get the legal Zooms, but you're really pushing it if you don't do it exactly right, because whoever doesn't like what's in that legal Zoom will can contest it because it doesn't follow the appropriate guidelines that that a will that you didn't handwrite requires in the state of Texas. But I've seen it done. The legal Zooms actually do work if you get it done right. And if you have the self-authenticating document attached to it,
Which is?
it's a particular, and I don't have the verbiage in front of me, but it's everywhere. It's in the statute. It basically says, and I'm paraphrasing here, that I was here when they signed the will, and this is my authentic will, and they basically, the two witnesses will certify that everything that they would prove up in court anyway. And the beauty about a self-authenticating will is if you've signed a will 50 years before, and I just did one just like this, then the attorney or the person trying to probate it doesn't have to go find those witnesses of a will. You die at 90, you did your will at 40.
Right.
The witnesses are probably dead. You don't have a good will if you don't have a self-authenticating one, and the witnesses are dead because no one can prove your will up. So the self-authenticating really takes care of all that. Or holographic, and it's in your own handwriting. Problem you have with your holographic, the biggest problem is down the road, if someone says, that's not their handwriting, that's not their will. So then how do you know their handwriting didn't change after 50 years? It may or may not have. You don't know. But you're the will that will pass muster more than likely will be one that was drawn up by a disinterested third party, an attorney generally, that sets out, has all the prerequisites by statute in there, has the self-authenticating languages with the two witnesses, and
Notarized.
and that's part of it. It's all going to be in there. The estates code has it all set out for somebody if somebody wants to attempt to do it on their own, exactly what's required, and then you can go through the whole process of getting it probated if you want to go that direction, and that goes to, like, you're not being able to find your was it your Nana?
His adopted
Grandmother,
grandmother.
yeah.
Adoptive grandmother. What did you call her?
Adopted grandmother,
My
Miss Honey.
Texas adopted grandmother, Miss Honey.
Miss Honey. I know
That's sweet.
it was some name. Miss
I
Honey.
didn't realize that she actually had a name other than Miss Honey, because everybody in
What's her last name? Honey.
No.
Okay.
no.
That was just a nickname?
That was just a nickname. I didn't realize for a number of years actually that she actually had a name. She called me on the house phone, and I wasn't there. She left a message, and she said, "This is Mrs. Jeanette DeLong. I'm looking for my damn Yankee. Call me right back."
And you're like, who is that?
It's like, "Honey, do you know who this Jeanette person is?" And she said, "That's Miss Honey." I went,
Oh.
"Really? That's her real name?" I did not know that. Everyone called her Honey.
And that kind of goes to the next question, because I haven't looked up. If she signed her holographic will, Miss Honey, would that be legitimate?
It is.
It could be, because that's what people knew her as, and that was her handwriting. And those were her. The most important thing in a state code is that the wishes, the intent that the person that dies wishes be upheld legally. And there's a lot of different ways to do it. But the holographic, if she'd signed Miss Honey and she had the, everything I own going in whatever direction, that would work. Now, you were saying that you found Miss Honey's will
Yes.
after the fact. That would be a good will. That goes to the next question, or the
But
next.
before we go to the next question, I want to say this about oral wills. Oral wills are valid. Say, like, for example, a listener of yours is laying on his deathbed or her deathbed, and they go, "Oh man, I forgot to, tell people what I wanted. Please give my Rembrandt painting or whatever to my great grandson Matthew." They can say it orally, but there are some very staunch restrictions on that. They've got to say it to a couple of people, and those people very shortly have to go write it down.
The witnesses, right?
The witnesses.
Right. And these days, with cell phones recording, that they are
Yeah, you can
invaluable
record
for
everything.
all evidence.
Yeah.
If
That's
someone's
true.
saying that, just have your cell phone going, because that's proof. You don't need all those witnesses, because the reason for writing it down in the old days was because you couldn't prove it. Everything
Right.
in law is being able to authenticate and prove. And now, of course, statement's going to come in. It's not hearsay, as long as in court, the court accepts it because
That's
it's admissible.
right.
And there's like all these hearsay exceptions, excited utterance. They're like, "Oh no, I changed my will. Everything goes to Sanford and Sons," or whatever it may be. I forgot what he always say before he died.
Elizabeth, honey, I'm coming.
Yeah,
I'm
Elizabeth.
coming.
Elizabeth. Okay, but what I was going to say was about your Miss Honey's will. If you had said that everything got distributed without probating the will anyway, that may be a good thing.
Yeah.
You've saved a lot of money. If there's not a lot of discord in the family, like we were saying, people get crazy when someone dies, and they go to fisticuffs or whatever. But if it was, my 4 kids are going to own my stuff equally, and all they had was a house, that was all she had left that was worth anything, and the 4 kids agree that the house should be sold so they can partition it for the money, which is how you dispose of property that, that's how it's equal.
Where there's a
Unless one of the kids wants to
dispute.
keep the house, then they establish its value through whatever means that they determine is reasonable, whether it be an appraiser, our agreement, our fair market value, because people are putting, you list it and find out the best one. Out of all that, once it's split, then the person then you can, if you haven't entered a contract yet, the person that wants it could have a first right of refusal because the kids agree, and then they can pay them their share, maybe through a mortgage. There's all different ways.
Well, that's all taken care of during the probate, I would assume.
Well, if there's, but I'm saying if
It
you
depends.
don't take it,
If there's a dispute over partitioning property,
if
and
there's no will, though,
that's a separate thing.
if there's no will, then you have to go to the intestate statutory.
Well, everybody's going to have a will. If you're listening to the show, everyone is going to have a will. Which brings it to part B to this question. You hear all the time that and this is for our loyal listener and fellow Blue Ribbon panelist, DV Tanya. You hear all the time about people leaving things to their pets.
Right. Right.
If you guys listen to my show, you know that I have the Apex Predator Posse, the boys.
And who are they? Your dogs?
They're Tanya's dogs, and I am living my life vicariously through her so I can have access to the Apex Predator Posse.
Oh, okay. Okay.
When she passes on, there's only two people that she has, a daughter and the boys. Can you leave money to a third party for care of your pet?
Yes. You used to not be able to leave money to your pets, but now you can. You can set up I don't even remember what it's called.
Well,
but
outside of a will, you can set up a trust, but you can also have within the will. There's provisions where you can have a person that will take care of that pet. The problem you're always going to have with that is you can kill a pet and it's not murder. It may be something, but it's not much. And whoever is the person that's going to inherit from that pet, because of course pets can't devise that, you're going to have to put a residuary provision in there in the event that the pet dies, the money goes here. And it better not be the person that's taking care of them if they're greedy because they might kill the pet. So that's the problem you're going to have is the pet can't make rules. They can't notarize something. So yeah, very well-off people will have their pets taken care of for life, but they've got somebody that they've set up in a trust. And the big thing here is you want the person that's the trustee not to be the person that's controlling things.
Right.
That trustee is probably should be bank and it's money. The bank's going to get a trustee fee if they're doing something like that. But if you really have that much money that you don't know what to do with, or maybe you just really care for your pet that much, then it's a little bit more expensive to make sure that your wishes are done properly. And I say expensive because after you're gone, there's got to be a lot of trust, fiduciary duty, that your trustee is going to do what you're asking. But there's also going to have to be, you're going to be paying that person to do it, to take care of them.
But it is legal.
Oh, yeah.
oh, yes.
Outstanding.
I believe it's not legal to leave money to your pet. I leave fee $50 million, and people have tried to do that over and over and over. But to establish for the care and provision of that pet, you can do that.
That's outstanding. Nick, I'm gonna. When's Tanya come over? She comes up for Thanksgiving. We're gonna come in. And we're gonna record. We're gonna bring the boys in, so you can see just how wolfish they truly
What
are.
are the boys?
They're Maltese poodle mixes.
Wolfish. A Maltese poodle mix wolf? Really?
Yes.
Okay.
They're
that's
apex
interesting.
predators.
How much do they
Really?
weigh?
Okay.
You should watch them stalk.
I can
They're
imagine.
natural prey, the majestic moose. and people make fun of them because of their little frou-frou tails. They're the apex predators with frou-frou tails. But in the wild, you have a gaggle. That's what a pack of these type of animals called. It's called a gaggle. And they communicate through the high grass by waving that frou-frou tail.
Oh, really?
That's my story, and I'm sticking to it.
Okay.
Sounds like
See?
girls to me.
Now you know why we had to have Dan as the straight guy.
Is he Lieutenant Dan? I keep wanting to call him Lieutenant Dan.
No, that is Gary Sinise.
Okay.
And I forgot it
no,
again.
That's the real Lieutenant Dan.
That is the real
But
Lieutenant Dan.
But you don't just for fun call your Dan Lieutenant Dan.
He's a grunt. I should let you know.
Okay. Oh well.
You know what grunt is, right?
I don't.
It's an Army acronym. It stands for ground reconnaissance, usually not trained.
Oh, really?
What? 10th Mountain, guys. I'm repping you.
Uh-huh.
That's infantry, guys. How am I doing on time? Oh, I got a bunch of time. I had a bunch of time. Well, not a bunch of time. Let's move on.
Okay.
Second question. We aren't married, but we've been together for 10 years. The veteran passes without a will, but we have property, cars, and furnitures that still need to be paid for. Am I responsible to pay it?
Well, I mean, I'm going to let you take off on this, and Cheryl will answer it. But the easy answer is if you're not married, two things. One, you might be married because you might have an informal marriage if you held out to people
That's
in the
in
state
Texas.
of Texas. If you live together and in Texas you've held out to people that you're married, even and cohabitated even 1 day, 1 hour, but you had to hold out to at least one person, like just one person once and say it, then you have an informal marriage, okay? But
You guys out there, and you know who you are, and the ladies, and you know who you are. See, I told you.
even if you said to in passing when you met his parents or her parents,
This is my
and
old lady
and you were
or
just trying to be
something.
nice, if you said it in Texas and then you went back and got it on at your lunch hour, then you're informally married.
But
Okay.
Tony, for 1 day, 1 hour?
Yeah, doesn't
It's
matter.
2
There's
years.
the statute does not say how long. There is no time. It could be just a lunch, roll or something. That didn't cohabitating. But usually it's more than that. Cohabitating means that you're living with them and everybody knows it. But you only have to say it to one person once. And a lot of the rich baseball players, their paramours and girls
yeah,
that
are
eventually
always
get dumped when they
claiming.
kind of age
Paramour,
out.
I like that
Yeah, when they age out and they've got a new squeeze. Then that's the one that's saying, "Hey, I was their wife," and and there's been lots of case law, lots of really big cases,
Oh, yeah.
like the big major league players that will say, "I'm not married to them," and one happened in Texas, and where it was I think it was a Houston Astro from a few decades ago, but anyway, I think the woman won. So got to be careful about that too. But that's a tangent. Your question was not that. This is like the bar exam. That was not your question. Your question was you were not married. If you're not married, then the person that is the significant other is really in a bad place because you go to the contract. If the car was purchased and they're also on the title, or they were
Right.
they would have to have title on the car. But let's say that the title wasn't on the car, but the loan was in both names. Well, that's really too bad for the person who's agreed to pay on the loan, but it's titled to the another person because they are responsible for that debt, even if they don't get to keep the car. So you want to be just like with houses. If you're responsible for the debt, you better also have some title ownership, and that happens in divorces all the time.
It sure
Someone will
does.
say, "Oh, I'll in the divorce, I'm going to give them the house," but they never get the loan changed. And so the loan is still, the bank is giving them a loan based on two persons' income. They give the house, in the divorce, the wife gets the house. Well, guess what? The wife doesn't pay the note. The bank is going after you or the husband.
husband.
I'm using
Well,
this.
let me give you a hypothetical. So, two people, they're living together. They're not legally married, but they've been together forever. The house is in his name. The mortgage is in his name. He passes. Surviving spouse, not a spouse, is left, and he's always said, in the will, he's left the house to her.
Okay, there's a will. She's got the house. Good.
So she can pay on that loan, but the house isn't in her name.
No, it is after the will.
Right.
If the will is probated, the estate has to distribute that, so the title now passes to her through the will. Now, it would be worse if there wasn't a will. That was
Right.
where I thought you were going with
I
it.
did too.
Because the intestate, if there's not a will, then the state of Texas has statutes in the estate code that says, in the event there's not a will, then it's going to go to what's called an intestate distribution. Testate is with the will, intestate's the other. And you can still have an intestate distribution even if there is a will if you don't probate it, because it's automatically going to default to
The statute.
if the will is not good or there wasn't a will, you don't want to probate it, you don't probate it in time, or for whatever reason, then you're going to default to the intestate statute, which says, depending on who is still alive, whether you've got only an aunt and uncle, or you have a bunch of, half kids from different marriages or whatever, it tells you exactly as a chart who it's going to go to.
Right.
And
And in what portions.
And you go to court for an intestate distribution, and the court will determine through an administrator, that administrator is going to, for a fee, of course, if there's enough money in the estate, create the deeds to get it into the people that would inherit under the intestate distribution. But it's really a bad thing if you're living together with somebody forever and you don't have the
Right.
wherewithal, guy or girl, to make sure that your name doesn't get titled in some of the stuff, or there's not a will or a trust. It's another way to getting around a will. If you create a trust, for example, on a piece of property, and the trust says that in the event of one of the death of whoever, whatever the terms of the trust are, then you don't even have to go through probate. The trust will automatically, through the trustee, they can the property, whether it doesn't have to be real property, it can be any property, will be distributed to the beneficiaries of the trust.
All right. That leads into the last question on wills before we get into probates, because a lot of this stuff goes from wills right into probate. I don't have a will. Will my spouse still get everything anyway?
I think Tony just kind of answered it, but she was talking about if you're not married to that person. If you are married to that person and you don't have a will, then the default is you're not testate, now you're intestate, and so the default distribution of your property goes by statute.
And so I guess your question is, if you're married, let's say we're married, okay? Jim, that's just an example.
This is a
okay?
hypothetical, Jim.
Hypothetical. We're married, and the house is in your name, okay? And and I'm just a stay-at-home mom, and I don't know anything about the law or anything. What happens? Will the house automatically go to me if we're married and there's no will? It depends on what the situation is with your kids.
Right.
If we're married and we've got 4 kids,
Assume we have no kids.
okay, so, then I believe if there's no other if there's no other siblings or your parents aren't alive, because let's say that you were young and this happened, then your parents would still get part of it. And I don't have the chart in front of me.
It's right here.
Oh, you have the chart?
Well, the questions that he gave us.
Oh, okay.
It's the bottom.
I didn't do my homework, but okay, so what is the answer? I
Well, hang
believe
on.
that if you don't have any kids, it's going to go to the spouse, though.
Right, with no children. If you have children from a previous marriage, but none with her, I mean, this is just memory, but it's divided something like your previous children get 2/3 of your estate, and your current spouse gets 1/3 of your estate. It's
Okay, and I'm going to reframe that just a little bit, because this is kind of like the way the estates code chart looks. If we're married and we have kids and you die, then I'm going to get my 50% community share of the house, and the kids are going to split the other 50%. That's just the way it works without a will. But let's say that you get remarried and you have kids from the first, and that's automatic. If you get remarried, the kids from the second marriage, there's a different split, because the first kids, if you are married to a different spouse, that spouse isn't going to get anything anymore, but she will get a 1/3 life estate, okay? But the question I thought you were going to was what happens if the wife is not even on she's not your wife, you live together, okay?
Nope. She's my wife.
You're okay, but
I have no kids. I don't have any other marriages other than her. But I died without a will.
okay.
But doesn't
if
she
the
doesn't she get
deceased-
everything?
If the deceased had no children, the entire community estate passes to the surviving spouse with no kids and no will.
Right.
All right. If the deceased had children, all of such children were also children of the surviving spouse, then the entire community passes to the surviving spouse. Finally, if the deceased had children
Yes.
or descendants other than those of the surviving spouse, this is what I was just telling you,
Right.
then the surviving spouse retains her
half.
1/2 share
Community
of the
share.
community property, and the descendants' 1/2 share of the community property is divided equally between the children or descendants.
The balance,
of the deceased.
the other 50%.
So in other words, she gets her own share, but all of his share goes to his kids.
And it doesn't matter if it came from that marriage with that wife or not. It's going to be split amongst the 50%.
If he had 15 kids from 15 different women, it would still go.
So a Navy guy.
Yeah.
Yeah, yeah.
Yeah.
Sorry, Pete.
It would still go. His share, she wouldn't get any of, and his share would go to those 15
And that
children.
that
equal shares.
just for the people that have been through a probate before, I forgot what year it was, like 2008. It was a little bit different because before when a will was probated and you were married and you had kids, then the the spouse would get 50% and the kids would get 50% right then if it was the same marriage. But that's changed now because if it was all one big family unit, now the spouse gets everything if even if there's kids alive. Because I know that when my dad died, we got 50% of his estate and my mom got 50%.
And what year did he die?
He died in 1986. He died
Right.
pretty young. But now that's not the case. If the law was then as it is now, my mom would have got everything, and we would have just been, just his kids,
Yeah.
Well, let's wrap this up because we're running out of time, and I want to make sure that we have enough time for everybody for all the questions. Let's
Okay.
get into probate.
Okay.
Again, we polled the listeners, and the number one question: exactly what is probate, and why do I even care?
I'm gonna try. I keep talking, but probate. The quick answer is I'm trying so hard. Probate is just taking a will and going to court and asking the court to recognize the will and the things that are in it. That's the short answer. But you don't need to probate a will if the exact same distribution will occur without it. So if you only own a house and your wife's going to get all the house, then why would you go to the expense of probating? You could go intestate and you can actually
Well, let me interrupt you. Do you have the choice
Yes.
of whether or not
you
you're going
do.
to probate or
Yes.
not?
You do.
Because they're not here to go do anything. They're dead already. And you don't have to probate. And there's something called emmuniment of title, which is you don't do anything, but you literally fill out an affidavit of heirship and you file it, and the property will already be legally through any title company of record. It will go to the person that is in that affidavit of heirship. And so that's the quick and cheap way. You literally do an
Those are
affidavit.
for small estates.
Yes,
like
small
50,000 or less.
Right.
Well, that would cover me.
Right. So emmuniment of title is the cheapest, easiest, if the only thing that exists is a house. And you only have the two partners together. You don't want to go through the probate. You don't want to go through all that because there's a lot of expense involved and you don't need to do that. You don't have to pay taxes because there's a threshold, has to be over, I think, like $1 million, 50 million, whatever. It's
now
really
it's like
high.
11 million point five.
I think I came up with a unique way personally for me to do it. Is I'm going to get all the people that think that I've left them something, and we're going to get them into a cage, and we're going to have a cage match. It's like Thunderdome. I think that would work. We could sell tickets.
Yeah, that's true.
If you were really rich, it would work. If you had lots of property, I'd want to be in there too. I'd be claiming I was like, a relative.
You haven't been paying attention. I am the ruler of my own country.
Oh.
What country is that?
Douglandia.
Oh, Douglandia.
As an attorney, I would be researching all your assets and looking for the fair market value of Landia.
I like it there. Everybody knows my name.
Yeah, no kidding.
So let's assume that we've decided that we're going to go to probate for whatever reason.
Okay.
How long does probate take? I've heard this thing that the will's been in probate forever.
Doesn't take very long at all. You can push a probate through in maybe, I want to say 2 months, 3 months here in Montgomery County. If the reason they go on forever is either there's a problem with the actual will, or you haven't done something you were supposed to do to finish the probate. You didn't do your inventory properly.
Right.
You didn't get the notice filed. You didn't pay the right fees. If no one's contesting it though, then the probates move really fast.
Right.
Really fast.
That's
like
usually
about,
for some problem or someone's dragging their
maybe
feet.
60 days, 90 days tops. They move real fast.
Well, if someone's contests the will, doesn't that
exactly right.
automatically go to probate?
Well,
Well,
it's-
you wouldn't be in probate unless the will was put before the court.
and declared valid
Probate
by the court.
is putting the will in front of a court, saying, "I want you to use this document that this person said was their will and administrate it through the court to make it legal." So you wouldn't be in court unless there was a will that you'd already filed and asked the court to sanction.
If there's a dispute over the validity of the will, you would be.
Then you have a will contest, and
Right.
those can go on a long time, and they're
That's
expensive.
different.
Dealing with somebody else's property, but
Right.
that you believe is yours.
Like I said, people get crazy when someone dies.
They
And
sure
it wasn't
do.
even their property. That's the
That's
crazy
right.
thing. They didn't earn it. Their mom or dad did, or their brother or sister.
I don't understand the fascination that some people have with, I have to have this thing from him or her that has passed.
I don't
It's
either.
like, it's only stuff to me. That's probably why I'm not rich, because it's only stuff to me.
You know
I was
what?
gonna
That's
get more.
really good. Don't the meek inherit the earth? That's really the way it should be.
I am a very meek and humble guy. You
Is
may have
that
not
why you
noticed
live in Douglandia?
No, actually, I live here in town because my wife refuses to move to Douglandia.
Please.
Doug
Yeah,
Landy.
yeah, but that's true. It is only stuff. But I think that they fight over those things because they have a memory with that person over that thing. Usually,
The blue couch. We have some people fighting over a blue Andrew Lloyd Wright couch or whatever. It was something that it had no value to anyone else, but there was a sentimental value. It was really, really important.
Right.
But I was reading this book, and basically, it's like you have to let go, and you really have to let go if it wasn't yours to begin with. I mean, what peace do you? I mean, isn't life just about having peace? What peace do you have when you're fighting over somebody else's stuff?
I don't think people want peace. Not everybody. You do, but a lot of people love to fight. I mean, you know those people
God,
that
but it
they're
drives
always
us
fighting
crazy
with
with
one
you.
person, and then they make up with that person, and then you're next. Now they're fighting with you, and they're mad at you.
And then they
don't
go back
want-
to the first person they were fighting with again. Oh, yes. Oh,
Yeah.
yes. I don't do domestic drama.
I am not friends with people like that because I know I'm next, and I don't want to be next.
I can't do domestic drama. I'll walk
I
away.
can tell you right now, I can't even. That's not in the realm of things that I can understand personally because I don't know anybody that really fights over stuff. To be
You've
completely
led a very sheltered life, haven't you?
well, I'm an attorney on top of it, but the people I represent are fighting over everything. It's like crazy, and it's particularly in divorces. It's like the coffee pot, or it's nothing. Kids. I'm not talking about people. I'm talking about objects. And when someone dies, all you have is unless there's a lot of money involved, and that's when it gets bad. People that are usually meek, peaceful, humble, don't really, they're not really that concerned about material things in the world. They're just, salt of the earth, whatever. It suddenly becomes a lot more important when you're talking about a $2 million piece of property, and they see their brothers getting a larger share than them. Then it goes to, who did my mom love more? Why is this happening? You're not going to get away with that because there's a fairness issue involved. The
Right.
fairness gets
I
killed.
want to put this
Right,
out
that's
right
a good
now in
point.
case any of my siblings are listening. Mom loves me best. I am the favorite child,
Yes.
just so you all know.
You know how many funerals I've been to where somebody gets up there and actually says, I was the favorite? I kid you not.
in a funeral,
and they're
wow.
laughing, but they mean it.
Yeah,
I am the favorite
or they
child,
wouldn't
and that's
say it,
Oh, so you're the favorite.
I'm the favorite, yes. That's my story.
and you're sticking to it.
Mom
Okay.
will agree with me, right, Mom? See, y'all heard her. She said I am the favorite.
Oh,
Last question. How am I doing on time? Oh, I only got 15 minutes left of the show. I got to book it. I've heard that you can't live in a house, pay the person's bills, or give things in the will to others while it's in probate. Is that true?
No, absolutely not.
I didn't think so because the creditors want their money.
The
They don't
independent
care who it comes from.
executor right
to do
away
that.
can move in
Yeah.
because you have to maintain the estate property. And whether you move in it because you need to maintain the estate because it's easier because everything's falling apart and you need to, you want to get insurance. But the independent executor, when there's a will involved and it's gone to probate, if it's an independent executor, they can pretty much do whatever they want without bond. They can move in, they can rent it, but they still have to account for the value of the rent back to the beneficiaries. They can't just move in and stay there forever. If the fair market value, because if you do that, your siblings are going to come to court and say, Judge, they're living it. That was my property. I'm getting that share.
Right.
The judge is going to have to settle things out. You're asking for a lot of trouble if you do that. You don't share it. But if you want to move in because you need to maintain it and the fair market value of the rent is offset by, all the accounting is done as the executor, then there's no reason you shouldn't do that. The better thing to do is to get a third party in there, to get a real estate agent and rent it because it's easier to quantify when it's at an arm's length
And
than
market
if you're
value,
in there.
fair
Because it
market
looks like you're gonna. What if you live there forever and your brothers and sisters want you to sell it for its value, the house that your mom lived in? Well, that's not fair to them because first, it's not going to sell as well if you're living in there unless you've got amazing furniture and a maid and all that stuff. You're running it down, and so there's going to be an argument about that. So you can do that, but is it in the estate's best interest? Because remember, you're not just doing it for yourself if you're the independent executor. You're going to get a lot of trouble if you don't follow through with your fiduciary duty to the beneficiaries. So you can do it, though.
The other part of that question is, I've passed. I have bills in my name. they still need to get paid.
And
But my
almost
estate's not settled yet.
almost always the estate that comes off the top, depending on whether it's a secured creditor or not. Secured creditor is just going to pick it up if you don't pay the bill on it. You know, the car has a car note or whatever. It may have equity in it, but you don't pay that car note, you know what happens. The tow guy is going to come get it. And then sell it or whatever they do, which they love to do that. And then they put it in their little storage facility, and then they make it so that there's no equity left because no one's picked it up because the person died, no one knew it. Or maybe they're in it. You know, that's a whole different thing.
So when I die, got a car note, I got credit cards. My somebody decides they're going to contest my will. Doug liked me best. He should have left me something. My wife still has to pay those creditors, or she loses the car. And
If it's her car. If it's a community property car, that you're assuming that the car title is in both your names. If that's the case, yeah, she needs to pay it because it's also
no,
her
it's
car.
in my name.
Well,
But
then
it's a
if
community
in-
estate, right?
Well, no,
No,
not.
no, it's true though. If the car is in your name and you bought it while you were married, it's community property. I don't care how
Well,
the title is.
that's true,
Okay,
right.
and she better pay it because like anything that's secured, if there's an agreement that was made, and let's just say you made it, it was only your name's on it, then yeah, if she doesn't go in there and pay for the car,
So the question here is, can she pay that car note using the checking account?
yes, of course. If she's the independent executor, because that person now has control over the
Steps
checking
into your
account.
shoes.
Because you have to go to the bank with the will and your letters testamentary and say, I now control this because this account, let's say the account did not have her name on it. This account that's Douglasb Inc. or whatever, the account is I now control all of the funds in Douglasb Inc. because I'm the executive of the estate and I was put in charge of it. Assuming that the
Brother Johnny, are you listening? I hope you're listening.
Well, I want to
Because
add
you're
to
the
that.
executor of the estate, so you got to pay all these bills.
Yeah, Johnny.
But
listen
if
to
he
him.
doesn't pay the bills and your wife has got a community property interest, then the car will be picked up. So as the executor, he's in big trouble if hasn't immediately, like you're supposed to when you're the executor, take inventory. And that's called that for a reason, to determine what bills are due and who would get it.
Who you owe money
Right.
to and all
because
of that.
because she could sue your wife could sue your brother if he was the executor and they came and picked up the car if he had control over the funds and he didn't pay the car note from the estate that had money in it and she lost her community property share. That's there's a cause of action there.
Yeah, but I was just doing a will thing where there was a signatory on an account that was in supposedly the estate, and the signatory on the account was the ex-wife, and that account became hers according to bank policy.
Well, it depends on how it's set
because she
up.
was a signatory on the account.
If she was a signatory, the way it's set up, even if she was a signatory, if it didn't, because bank accounts are a little bit different. If the bank account is set up for it to be a survivor bank account, then when you die, it automatically goes to a survivor that you've named. If she's a signatory and she was also a joint owner and had rights of survivorship, she would get the whole account. So banking law would kick in there.
We're gonna have to wrap this up because Engineer Dick is giving me the high sign that I only have 4 minutes left. So I have to do the announcements for the day, for the month. But first, before I forget, I have to give a shout out to our sponsor who pays for this show, East Meets West Productions. East Meets West Productions, as you all know, is a full-service marketing and consulting firm helping vets start and fund their business for over 25 years. For more information, please call 361-404-0044. And we have a bunch of announcements to get to. What's today? Today's the 4th, right?
Today is June 4th.
So tomorrow, there will be the Memorial Monument dedication hosted by the Montgomery County Veterans Memorial Park. It's going to be at the Montgomery County Central Library. So y'all get down there. It's at 10:30 a.m. June 6th, and I love this, the Taste Fest 2019. Do you have tickets for that, Dick? Dick has tickets. I'm not going to be here. I got to go to Corpus tomorrow. Today. But yeah, go to this. This is great. Me and Joe went last year and we were stuffed. It's at the Lone Star Convention Center and Expo out over on Airport Road. It is June 6th from 5 to 8 p.m. Contact the station. Dick says he has a couple of tickets left.
And what is it?
Taste Fest?
Uh-huh.
Oh, all of the local eateries
Oh, neat.
Fun.
They get together in the convention hall and they set up their little tables and whatnot.
Yum.
And then you just go around and you taste everything.
That's
to
Thursday
including
night?
wine. That is June 6th. Yes, it is Thursday. Thursday
Yeah,
night.
that sounds yummy.
Dick, you should give the girls some tickets.
Yeah.
Yeah.
Dick.
How much do the tickets cost?
I believe you can order them online at conroe.org for, I think it's either $12 or $15. That includes 2 adult beverages.
It was well
And
worth it.
then,
Really?
But I think they're a little bit more at the door. They could be cheaper. They could be $10 right now.
That's a good way to
But-
find good
And,
restaurants.
and,
Yeah.
and if you stay to the end, all the ice cream that isn't eaten, they'll give it to you.
Oh, really?
Yes.
melted.
Yes. No, it hasn't melted yet. It's good. We also have Market Days, June 6th from 4 to 8 p.m. at Heritage Park. That is a particular favorite of ours. Go down and get your fresh veggies. But what is the most important thing that is happening this month in Conroe on June 6th is Chick-fil-A is opening a new store,
Oh, where?
Yum.
South 336, over where the
Really?
new Kroger's.
Oh, yes, yes, yes.
Yes.
I've been
right,
waiting.
right.
I went to the Whataburger right next door, and I thought, why isn't anybody at Chick-fil-A? And it was because they
Grand,
weren't
grand
open yet.
opening Thursday, yes.
Good for them.
Doors open at 6:30 in the morning.
Wow, pretty exciting.
That is the most important
But the
thing. that's happening.
Heritage, where is that at?
Heritage Park? He sits down and have 2 minutes. I don't know where Heritage Park is off the top of my head. But I have to close up the show
Okay.
because I'm getting the high sign. So I'll do the regular closing. That about wraps up our show for today. Thank you all for attending.
Thank you for asking us.
Tony, Cheryl, thank you so much for being here. We
Thank
have you
you.
back on again.
Sounds
We have
great.
less questions.
Doug
Morning.
Landia.
No problem.
They have elections.
I might have to come see you for that. Yes, we do have elections. I'll have to tell you my rules offline.
Is it a kingdom? Fiefdom?
Yes, it is. It's a
You're the
dictatorship.
king.
I want you to tune in July 8th. It'll be after the 4th of July, but I'm going to do something special for the 4th of July. Rumor has it that we're going to have some people in the studio that are going to talk about what it takes to become, to hold a public office here in Montgomery County. I want to leave you with this awesome song, as I usually do. This one is by Sailor Jerry, our friend. It's called Going Away. You can download the song from our website or at sailorjerrymusic.com. She has her new album out, so go get that. And while we're listening to this, let's remember our brothers and sisters that are wearing the uniform, that today are standing in harm's way to protect our freedoms and our liberties. If you are wearing the uniform, I want to say to you, thank you. I want to say to you, I'm proud of you. Until next month, stay vigilant, stay safe.
My old man wasn't happy when I raised my hand and swore to protect and serve this country when the devil was at her door. But Mama wasn't worried because she saw the fight in me. She said, send the ones who are unafraid to make damn sure that we're free. If it's for my country, if it's for my town, it might be hell or fire raining down. I'm going anyway. I know the risk I'm taking. We may not make it home with my brother.